Hello and welcome to what is episode 5 of the Kielich Law Firm podcast. I'm Adam Kielich, the principal attorney at the Kielich Law Firm, and today we are going to talk about employment background checks and some of the things you can do to help take away criminal records from those background checks. Still working with the very basic equipment that I used on the first several, all the other podcast episodes. I noticed with the last episode that the sound was really clipping and it's kind of distorted. I'm not going to go back and re-record 45 minutes of audio, so sorry. But hopefully I've got the microphone issue fixed and all the clipping has gone away and won't be a problem going forward. So that's really the only housekeeping issue. I guess we should go ahead and just jump into the content. And so, as I mentioned in the beginning, we're talking about employment background checks and some of the mechanisms available to help get rid of some of those criminal records that are showing up on background checks, and why it's important that you may want to take advantage of some of those mechanisms. So today we'll talk about what shows up on employment background checks, why it's important to know what goes on in those background checks and how they're used by employers or potential employers. And then we'll talk about the real issue, which is the remedies to help take away some of those criminal records so that your background is a little cleaner. So let's go ahead and talk first about those employment background checks and what shows up. So a large number of employers now are conducting background checks on applicants for jobs. There's a number of reasons why employers do this. In certain jobs or certain industries, it can be mandatory that employers conduct background checks, or as part of licensing for a job, the employer has to conduct a background check, or a background check is conducted by the licensing agency. But a lot of employers just prefer to perform those background checks as a precautionary measure to see who they're hiring or who's applying for the job at very least, and try to figure out, is this person going to be a good fit for the job? Is this a person who has some problems? And if they are, maybe we don't want to hire that person, right? I mean, this stuff is all fairly obvious. What shows up in these background checks can be important even if you're not required to get some sort of license, or a background check isn't required for your job. It can be a real problem because the economy really hasn't bounced back from the drop-off in 2008. And to the extent that it has built back, there's still a big shortfall in employment. Forget about the Texas miracle and what unemployment numbers are showing. The truth is, a lot of people are having problems finding jobs. And employers know that. Employers get slammed with applications for jobs. So for them, they really have their pick. It's a buyer's market for employees. And anything that might make an employer raise an eyebrow about an applicant is going to be a good opportunity for that employer to pass on an applicant. So whatever is popping up in a background check could be the difference between getting a job and not getting a job, even if it's something fairly minor or something that doesn't actually prove bad conduct on the part of the applicant. So it's important to know what's going to show up on a background check, how they're conducted, and if you've got some bad stuff out there or some questionable stuff out there, how to go about trying to clean that up. So when employers conduct those background checks, there's a number of different ways they can perform them. Most employers contract with a third party to perform the background check. There's some technical reasons about why employers do it that is probably beyond what you really want to know. But ultimately, the information that's pulled is mostly coming from databases that collect public records, both criminal records that are pulled from courts or law enforcement agencies, and civil judgments that come from civil courts. They'll pull credit records, which may show some other some civil court activity, as well as, of course, late payments on debts, unpaid debts, that sort of thing. Some employers make the bad decision to go fish around on Facebook or other social media sites to try to find information about their applicants. There's some reasons why employers shouldn't do it, but employers can, and some employers will look at Facebook, they'll Google people, and just see what comes up. All of this information collectively kind of falls in that employer's background check and helps give them an idea of what kind of problems you may present, what kind of problems you've had in the past. And of course, if you've, say, filed suit against an employer over discrimination or wages, it's not too hard to find that stuff even through Google. So those can all be problems that an employer is looking for. And with criminal records in particular, employers are especially concerned about what kind of criminal record their employees or applicants have. Some of the obvious reasons why are theft, fraud, writing hot checks, the kind of crimes that suggest irresponsibility with money, with other people's property, with treatment of other people. Assault is another one that can be important. And for particular jobs, certain crimes can be an issue. For example, trucking jobs or other jobs that require time spent driving around. DUIs can be important. Reckless driving. Those can be big problems for employers because it directly relates to the job responsibilities. So employers are going to want to check out and see what kind of bad things you've done. And one of the problems is that employers can capture information about arrests, indictments that were never prosecuted. And although these things by themselves do not prove guilt, do not prove you did anything at all, the problem is employers look at that and, like many people, they think, hey, where there's smoke, there's fire. So if you were arrested for DUI and you got off, it could be the fact that you were driving drunk, but you hired a good attorney who was able to get you off. That doesn't mean that you may not drive drunk again or that you don't have a problem driving drunk. So an employer who has maybe 100 applicants for a job might just pass you up because you have that arrest. That's a problem. If you're a person who has something going on in your past that's showing up as a criminal record, that can be a real problem, not just for getting jobs that are specifically tied to whatever criminal record you have, but just in general, employers can toss people out just because they see some sort of criminal record out there. And most employers, when you fill out an application, they'll ask a specific question about whether you have ever been convicted of, arrested for, or received deferred adjudication for a crime, and sometimes they'll specify other than a traffic offense or a Class C misdemeanor. This question kind of works both ways. If you have been, if you should answer that question yes, they want you to explain it, and that's pretty much going to avoid them having to conduct a background check, because there's a really good chance they're going to toss out your application. If you answer no, but the answer should be yes, you might slip by for some reason. Maybe the background check doesn't show it, or the employer may conduct a background check months after they've actually hired you. That does happen. Well, the problem is, if the employer has hired you, maybe you're doing a great job, but then they find out that you lied about something that they may not have even cared about. The fact that you lied becomes a problem, and now you're dishonest, you're untrustworthy, and the employer has a good reason to fire you. 99 times out of 100, if an employer finds out you lied about this question, even if it does not care about the underlying crime or arrest, you will not survive in that job for very long. So it's a real problem just having to answer that question if the answer should be yes. If you have an opportunity to be able to answer that question no and survive a background check without a criminal record popping up, you really should take advantage of those opportunities. And the law does provide a handful of mechanisms to get that done. Now, the bad news is, and we should get this out of the way now before you keep listening, if you have been convicted of a crime and your crime was not pardoned, which almost never happens in Texas, or your conviction was not overturned by an appellate court, there is almost no way under Texas law for you to avoid having those convictions show up on a criminal record. The remedies available at law, besides having a conviction overturned or a pardon, apply to arrests and other criminal records that relate to crimes you were not convicted of. Maybe the prosecutor decided not to prosecute, the charges were dismissed, you were charged, you were indicted, you went to trial, you were found not guilty. Or in some cases, you accepted deferred adjudication or some other pretrial diversion arrangement to avoid actually being indicted or going to trial and being found guilty. In these cases, these mechanisms that we're going to talk about may be applicable. So, unfortunately, if you are convicted, you made some bad decisions, you did your time, the problem is you can't just get rid of those. You're stuck with them. The remedy for you, unfortunately, is time. Most employer background checks will only go back 7 years. There are some exceptions where that's not the case, but generally employer background checks only go back 7 years. So you've got to wait for those convictions or the tickets you pled guilty to drop off on this 7-year time period. And again, that's not universal. There are a number of jobs where employers can look back beyond that 7 years. but at least at that 7-year point, you've got some opportunity to see some of it wipe off for a number of employer background checks. So let's assume at this point that anybody with a conviction that has not been overturned or pardoned has decided to stop listening, and the people who are listening might still have some opportunities to have these criminal records dealt with because it did not result in a conviction, or a conviction that continues to exist because it was not overturned or pardoned. There's basically two remedies that the law makes available to scrub some of these records out of background checks. And these are expunctions. Sometimes people call them expungements, but it is actually expunctions. The other one is a nondisclosure order. They work differently. They have different effects. They're not equal. But we'll talk about each of them and how they work and which one is better for you. So let's first talk about expunctions. Expunctions are the best. If you can get an expunction, you should always pursue the expunction. And what an expunction is a complete destruction of the criminal records. No background check will find these records. An expunction order from a district court in Texas instructs law enforcement agencies and courts to destroy, not seal, but actually set them on fire, put them in the shredder, at least throw them in the trash can, and make sure that they're actually sent to the dump so that nobody ever finds them again. The expunction order will also tell civil agencies like credit reporting agencies, Experian, TransUnion, these guys, to destroy any records they have, and any of the databases that sort of secondarily collect this information, they also have to destroy the records. So it's as though the criminal records never, ever existed. Now, expunctions are only available in certain situations. They're available if you were arrested for a felony and not indicted, arrested for a misdemeanor and no information was filed. You were arrested, went to trial, but found not guilty. You were arrested, went to trial, convicted, but that conviction was overturned or pardoned. You were arrested or cited for a crime, and the charges were dismissed without a trial. You completed a pretrial diversion that resulted in closing the file, or deferred adjudication only for a Class C misdemeanor. That's it. Now let's talk a minute about the difference between pretrial diversion and deferred adjudication. These are two entirely different things. For the purpose of an expunction, it definitely matters which is which. For deferred adjudication, you accept a guilty plea, or at very least, you plead no contest. In exchange, the courts and the prosecutor agrees not to pursue the case for a period of time. You're put under community supervision, although you may not have to do anything for it. And if you are not cited with another crime within a certain period of time, the prosecutor agrees not to pursue whatever the original crime was. If you've had some sort of traffic ticket or other minor ticket where you pled guilty and paid a fine or took defensive driving or something, you may have accepted deferred adjudication for those offenses. The important aspect here is that for deferred adjudication, you have to enter a guilty plea or a plea of no contest, which is essentially the same for criminal purposes. A pretrial diversion program is a specific program in which you do not enter a plea of guilt or no contest, but you perform some similar kind of community supervision program. It's not actual community supervision or probation. You may complete some sort of class program for alcohol consumption or driving or whatever. You often have to show that you have not been convicted or cited with any other crime with a period of time. So it can be very similar to deferred adjudication, but the difference with the pretrial diversion is that they're usually specific programs for felonies or Class A misdemeanors, and there is no plea of guilt. With these pretrial diversion programs, if you complete the program, the prosecutor dismisses the charge or at least agrees not to pursue it. And then when the statute of limitations runs out, it's gone. So any pretrial diversion is available for an expunction or deferred adjudication for a Class C misdemeanor. We'll talk about what happens if you take deferred adjudication for a Class A or B misdemeanor, but for now, just know that they're not available for an expunction. So if you have some sort of arrest or a ticket was issued for some crime in your past, but there was no conviction, an expunction is available to you so long as you meet a number of specific requirements for whatever the crime was that you were alleged to have committed or you were arrested for. One of the most important restraints is a time restraint. If you were cited or arrested for a crime and no indictment was filed or an information for a misdemeanor or the charges were dismissed, if you're still within that statute of limitations, the prosecutor can still come back and file those charges, file the indictment, file the information, and pursue the case unless the prosecutor has agreed not to do that. So it's important if the arrest or citation has occurred within usually between the past 2 to 4 years, the prosecutor may be able to come back around and pursue those claims or the charges. And in that case, you may not be able to obtain an expunction order just yet. Now, some prosecutors will agree that they're not going to pursue the charge, so go ahead and get the expunction and take care of it. Not all prosecutors are that nice. Some offices are more aggressive about opposing those expunctions. But if you meet the requirements for the expunction, you should try to get it if you can. Get those records destroyed. That way, it'll be scrubbed from a background check forever. Now, let's say you've got something in your background that's not quite a conviction, but doesn't qualify for an expunction. The other option that you could take is what's called a nondisclosure order. A nondisclosure order is kind of like an expunction, but not as good. What a non-disclosure order does is seals records rather than destroy records. A non-disclosure order instructs these law enforcement agencies, the courts, private entities that collect this information to seal their records so that they are not available in a background check. Now, the non-disclosure order does not seal the records permanently from anybody. Like an expunction order destroys the records, nobody can come back and find them. In a non-disclosure order, the records are sealed, but certain government agencies can still pull those records. That can be a problem with certain types of licensing for jobs, or certain jobs with those government agencies that can still pull the records, because they'll still be able to find that information. And in some cases with licensing for particular types of employment licenses, the licensing agency may be able to find the information, but may not be able to use it as a reason to deny you a license. But if they know that this information is out there, and there's something else that they could use to deny you a license, you don't really want to be in that position where they can take that information that's been sealed and sort of sneak it into that other reason to deny a license. But the non-disclosure order is better than nothing, better than just having that information out there and letting them make a decision based upon an arrest or some silly ticket that was issued to you. You could obtain a non-disclosure order for any reason that you could obtain an expunction. But if you have an expunction available, you're going to get it. You're not going to go after a non-disclosure order. Where the two do not overlap is where you've accepted deferred adjudication for a Class A or Class B misdemeanor. Remember again, if you accept deferred adjudication for a Class C misdemeanor, you can get an expunction, but for Classes A and B, you have to get a non-disclosure order. The non-disclosure orders are a little tricky. Just because you accepted deferred adjudication in the past does not mean you're entitled to a non-disclosure order. There are a number of misdemeanors for which a non-disclosure order is not available. And if after you accepted deferred adjudication, you have subsequent criminal history, you can be prevented from obtaining a non-disclosure order. Not just that the judge could choose not to issue the order, but the judge may not be able to issue the order even if he or she wants to. So again, if you can get the expunction, you should take it. If you can't, and a non-disclosure order is available to you, you should get that instead. Some of the particulars about the crimes that they apply to and what kinds of subsequent criminal records can prevent you from getting it is really more complex than what we want to get into today with this podcast. If you are interested in obtaining an expunction or non-disclosure order, whichever may be available to you, it's really best to work with an attorney. And the reason why is, first of all, you want the attorney to review the options and see which of the two, if either, are available to you, and which one is going to be better suited for you. And again, if you have an expunction available, that's going to be your best option. But because of other things in your criminal record, the expunction may not be available to you, or a non-disclosure order may not be available to you. An attorney can pull those records, take a look at it, and assess your options for you. You may have other things in your background that an attorney can help seal or remove or at least obscure to help make it easier for you to get a job that you're qualified for. An important point why you should work with an attorney is that neither an expunction nor a non-disclosure order are automatic. If you apply to a court in Texas for one or the other, the judge does not have to grant that order. And in fact, the law enforcement agencies who have charged you or given you tickets or arrested you, they can challenge either one. And if for some reason they do challenge it, having an attorney on your side is going to be the best offense against those law enforcement agencies to try to convince the judge that this is an appropriate thing to do and that all of the legal requirements to obtain either one is available to you. Earlier, we talked